Good morning. We're the takings panel. So let me introduce the panelists to you, and then I'll give you a little brief summary of the three decisions that the Supreme Court rendered in the last term. I don't think we know what they mean yet, and the panelists may talk about them or they may talk about something else, so we just see where it goes from here. First, I'd like to introduce James Huffman. He's the Dean Emeritus of Lewis and Clark School. He taught constitutional law, natural resource law, torts, law and economics, and jurisprudence for 4 decades. He's written extensively on property rights, takings, and public trust doctrine. He's the former chairman, longtime member of the executive committee of the Property Rights and Environmental Practice Group. He recently served on the Hoover Institution Property Rights, Freedom and Prosperity Task Force. And most importantly, he has 2 books coming out very recently, Private Property and State Power, and Private Property and the Constitution. He holds degrees from Montana State University, Fletcher School of Law and Diplomacy, and the University of Chicago Law School. Our second panelist is Paul Beard. He's the principal attorney in Pacific Legal Foundation's Property Rights Group. As head of the PLF's Coastal Land Rights Project, he oversees litigation against coastal land use agencies that violate landowners' private property rights, especially the California Coastal Commission. His cases on behalf of property owners include challenges to unconstitutional conditions on land use permits and the unlawful assertion of jurisdiction by land use agencies over private property and its development. He did his undergraduate work at UCLA and graduated from Cornell Law School. Our third panelist is Stuart Stirk. He's the Mack Professor of Real Estate Law at the Benjamin Cardozo School of Law, where he teaches courses in property and land use regulation. He's also taught at Columbia, NYU, and the University of Pennsylvania. His scholarship includes a number of articles on takings law, and he co-edits a law school casebook on land use regulation. He got his undergraduate degree and his JD from Columbia Law School. Our fourth panelist, who's very popular because he just came from a panel immediately before this, is Thomas Merrill. He writes widely in fields of property and administrative law, and there are like a zillion articles I could read to, but I don't think I need to. He's a graduate of Grinnell College, Oxford University, where he was a Rhodes Scholar, and the University of Chicago Law School. He clerked on the DC Circuit for David Basildon, and he clerked on the United States Supreme Court for Harry Blackmun. He was Deputy Solicitor General at the Department of Justice, and he previously taught at Northwestern Law School and Yale Law School. So it's a pretty distinguished group. I think they know a lot, and maybe they'll tell you a lot. All right, the 3 cases that we're going to talk about, or that I'm going to introduce to you, came out this past term. The first one is Koontz versus St. Johns River Water Management District. The Koontz were Florida landowners. They claimed that taking of his property when the state conditioned a permit for commercial development of a small shopping center on his land with payment for improvements to a government-owned parcel of land which was pretty distant from his property where he wanted to build the shopping center. He challenged the constitutionality of the condition, claimed it violated the nexus and rough proportionality tests of the Nolan-Dolan cases. He refused to accept the permit, so no permit was issued. The Supreme Court agreed with Koontz, reversed the Florida Supreme Court, which had held against him, holding that the way the Florida Supreme Court dealt with Koontz's application ran afoul of both Nolan and Dolan. Justice Alito wrote, "Those cases, the Nolan-Dolan cases, reflect an overarching principle known as the unconstitutional conditions doctrine that vindicates the Constitution's enumerated rights by preventing the government from coercing people into giving them up. These cases involve a special application of this doctrine that protects the Fifth Amendment right to just compensation for property that the government takes when owners apply for a land use permit." He commented, Justice Alito commented, that land use permit applications are especially vulnerable to the type of coercion that the unconstitutional conditions doctrine prohibits because the government often has broad discretion to deny a permit that is worth far more than the property that it seeks to take. He also said extortionate demands for property in the land use permitting context run afoul of the takings clause, not because they take property, but because they unpermissibly burden the right not to have property taken without just compensation. As in other unconstitutional condition cases in which someone refuses to cede to the constitutional right in the face of coercive pressure, the impermissible denial of a government benefit is a cognizable injury. That was the holding of the court. The second favorable decision in these takings cases was when the United States Supreme Court ruled unanimously that federally regulated raisin farmers may file as an affirmative defense takings claims in federal enforcement actions involving the imposition of fines or penalties. This arose from two raisin farmers who refused to give between 30 and 50% of their crop to the government for free every year. So the government fined them $700,000. So they challenged this in district court, in federal district court, saying that this regulation violated the takings clause. The district court held that the Hornes could not use the takings clause as a defense against the regulation. They said that all taking claims over $10,000 must be brought in the U.S. Court of Federal Claims under the Tucker Act. The Ninth Circuit affirmed and said that the government first, that the plaintiffs would have to pay the money and then sue the government to get the same money back. Well, Justice Thomas would have none of this. He wrote for the majority. He said that this comprehensive enforcement scheme that the Department of Agriculture was trying to enforce on the plaintiffs displaced the jurisdiction of the Court of Federal Claims, gave jurisdiction to the district court to hear that takings defense. Justice Thomas said, in the case of an administrative enforcement proceeding, when a party raises a constitutional defense to an assessed fine, it would make little sense to require the party to pay the fine in one proceeding and then turn around and sue for recovery of the same money in another proceeding. We are therefore satisfied that the petitioners raised a cognizable takings defense and that the Ninth Circuit erred in declining to adjudicate it. The last case of the trilogy of last term is Arkansas Game and Fish Commission. And that was a case that came out of the Federal Circuit. The Federal Circuit held that the U.S. Corps of Engineers had flooded state-owned property, which is sort of unusual. It's not private-owned property, for 6 years, but this constituted a temporary taking. So they refused to recognize it as a taking. Well, several Federal Circuit judges disagreed. They filed dissents, and the Supreme Court took it up. They reversed. Justice Ginsburg wrote the opinion for 8 justices, and it was kind of a weird, sort of backwards, narrow holding. It said, no decision of this court authorizes a blanket temporary flooding exception to our takings clause jurisprudence, and we declined to create such an exception. All right, so where do we go from here? The Arkansas Game case was remanded to the Federal Circuit. They heard argument in September of this year. The Koontz case was remanded to the Florida Supreme Court, which remanded it to the Florida District Court in October. The Horne case was remanded to the Ninth Circuit. They're going to hear oral argument on Valentine's Day next year. So now we'll ask our panelists, what does this mean, if anything? Thank you. All right? Professor Hoffman.
Thank you very much, Judge. It's a pleasure to be here and to talk about a topic that seems to have been on the agenda ever since I went to law school 40 years ago. And I would say a lot has happened and not much has happened in those 40 years. I'm going to talk fairly generally, and I think, at least based on our phone conversation a week or so ago, the others are going to be a little more focused. I think that property rights owners and property rights advocates generally see these 3 opinions as positive, and indeed they are positive in the sense that property rights owners won in each case. But I think it's important to also recognize that these cases, like every takings case for the last several decades, really looks at takings law on the margins and doesn't really look at what I think is the fundamentally flawed foundation that has led to what Justice Kagan describes in her Koontz dissent as the, quote, notoriously difficult and perplexing standards of takings law. Kagan, in that dissent, is concerned that the majority's holding in Koontz may oblige land use regulators to apply those difficult and perplexing standards in their implementation and enforcement of ordinary land use regulations. Well, if you think about it, what a strange argument that is, or at least implies. The courts should give regulators a pass because the Supreme Court has established a difficult and perplexing standards for them to implement. But that is exactly what the court has done in takings jurisprudence. It has given government a pass in all but a very few cases. Now, just to remind you, and in the spirit of textualism, which has been much discussed at this convention, let me remind you what the provision of the Constitution is that we're talking about. It says, quote, "Nor shall private property be taken for public use without just compensation." Now, as Richard Epstein argued in his book written in 1985, Takings, Private Property, and Eminent Domain, that clause really implies three questions, although you wouldn't know it from reading Supreme Court opinions. First, has there been a taking? If there hasn't been, the case is over, it's done. If there has been a taking, is it for a public use? If it's not for a public use, even if just compensation is paid, it's not constitutional. Thirdly, if there is a taking and there is a public use, has just compensation been paid? If just compensation has not been paid, it must be, or the regulation must be rescinded, although the government might be liable for temporary taking. In sum, the government may take private property for public use with just compensation. Well, way back in 1922, in the case of Pennsylvania Coal against Mahon, Justice Holmes articulated two concepts, one of which has been largely ignored to the detriment of takings law, and the other of which has served as a foundation of takings law, again, to its detriment. After stating that, quote, "The government hardly could go on if to some extent values incident to property could not be diminished without paying for every such change in the general law," unquote, Holmes observed that many, if not most, regulations provide what he called average reciprocity of advantage, by which he meant that, roughly speaking, they burden everyone and provide everyone with benefits. Holmes might have intended to suggest that those burdens were therefore not takings, but as Epstein says, and I agree, the more coherent understanding is that they are takings for which compensation has been implicitly paid by the benefits received, generally by the population. So I think if courts better understood that concept and applied that concept, it might alleviate some of the fears that government will be disabled if it must pay for every burden imposed. So we'll score one for Holmes, but Holmes also gave us the totally unhelpful idea that a regulation is a taking if it goes, quote, too far. How far is too far? Well, imagine that the law of property, private property, provided that a physical intrusion on private property constitutes a trespass unless it goes too far. Who would decide how far is too far? How far is too far? Property owners would certainly have to guess on that question, and ultimately courts might decide, but such a rule would result in disabling uncertainty. But that is the way it really is with government takings law. Well, in 1978, the Supreme Court came up with a formula for the determination of how far is too far. The so-called Penn Central test instructs regulators and courts to determine whether a regulation has gone too far by assessing the economic impact of the regulation on the property owner, the extent to which the regulation interferes with investment-backed expectations, and the nature of the government regulation. So there you have it now, explain to your client how far is too far. This Penn Central test requires regulators and courts to balance the interests of the property owner against the interests of the government. In Arkansas Game and Fish, a unanimous court reaffirms its commitment to this ad hoc approach, while rejecting the government's claim of per se immunity in temporary flooding cases. The Koontz majority also reaffirms the Penn Central test. Who do you suppose prevails when this test is applied? A test which basically says we'll balance private self-interest against the public good. But if the takings clause is to have any meaning, there have to be occasions when property owners prevail, and so the court has given us two per se takings which satisfy that need for some circumstance in which the takings clause actually means something. Of course, those are physical intrusions and total loss of economic value. Well, students of constitutional law and former students of constitutional law might notice that this resembles equal protection law in a way. That is, if in equal protection law, if you plead that you have a fundamental right that's been violated or that you've been discriminated against based on a suspect class, you get strict scrutiny and you almost always win. Otherwise, you get rational basis review and you lose, and we know there's some intermediate stuff that allows for a little more discretion and balancing by the court. But it's really all balancing. That's all this levels of scrutiny analysis business is, which has been applied much more broadly than just to equal protection law. In takings law, the government almost always wins, except where there are per se takings, or as we saw in Nolan and Dolan, where the government demands what would be a per se taking, or theoretically a regulatory taking, as an exaction in return for a permit. In Koontz, Justice Kagan objects that the majority has improperly introduced heightened scrutiny to regulatory takings law. This has to be a mistake, she might have added, because it is well established that challenges to social and economic laws and regulations are subject to deferential scrutiny, or the deferential scrutiny of rational basis review. But if you think about it, aren't most regulations and laws social or economic? For example, if you have a regulation that regulates public demonstrations in the streets, for the purpose of maintaining order and commerce, the free flow of commerce, if the claim is that it's a First Amendment right of assembly or speech, you get strict scrutiny, even though it was really an economic or social regulation. But a land use law aimed at the same purposes is presumptively invalid. The difference is not the nature of the regulation or law, it's the nature of the rights claim at issue. Economic liberty claims, property and contract, have second-class standing in a hierarchy of individual liberties. But nowhere in the Constitution is there authority for the idea that economic liberties warrant less judicial protection than political and civil liberties. Most people are familiar with Potter Stewart's statement from Lynch against household finance in 1972. The dichotomy between personal liberties and property rights is a false one. Yet, since 1972, the dichotomy persists, with Penn Central balancing as the mechanism for assuring that property rights may be routinely compromised to the ambitions of the state. Does the Koontz decision threaten, quote, to subject a vast array of land use regulations applied daily in states and localities throughout the country to heightened constitutional scrutiny, as Kagan contends in her dissent? Has the court taken, quote, a revolutionary and destructive step that casts the burden on government to justify land use mandates, as my friend John Echeverria wrote in the New York Times shortly after the decision? Well, we can hope so. The unanimous Horne court was apparently unconcerned with the government's objection that allowing property owners to seek injunctive relief in district court improperly burdened the government with proving that its raisin marketing program did not take Horne's property. And the majority in Koontz did effectively burden the government with demonstrating that its proposed exaction is not a taking. But in none of the three cases did anyone on the court challenge the core presumption that government power trumps economic liberties. Indeed, Alito's opinion for the majority in Koontz goes to great lengths to fit the holding within existing takings doctrine. The government's offense, according to Alito, is that it may have imposed an unconstitutional condition on the plaintiffs, so the case is remanded to the Florida court, as the judge pointed out. The Florida court will presumably apply the nexus and proportionality tests of Nolan and Dolan and may well conclude that demanding money for improvements to other government-owned lands as a condition for a permit meets both tests. But perhaps the court has at least, in the case of property rights, put a thumb on the scale in favor of economic liberty by burdening government with the task of giving due consideration to whether or not its regulatory actions might result in unconstitutional takings. And why shouldn't the government have the burden of demonstrating that it is not violating the rights of its citizens, particularly a government instituted, in the words of the Declaration of Independence, to secure the unalienable rights of those for whose consent was required for that government to exist in the first place. Thank you.
Thank you, Dean Huffman. Attorney Beard. What's that? You're up.
So I thought I'd discuss the Koontz decision in the context of permitting exactions. Pacific Legal Foundation took up the Koontz case earlier this year, argued the case, and obtained a 5-4 victory in that case. But I think in order to highlight the significance of the decision and what it might mean in the future for land use regulations, we need a bit of a description of what the state of the law was before Koontz. And all of this really began in 1987 with a decision called Nolan versus California Coastal Commission. Now, this area of the law is a very narrow area in takings law, but it is probably among the most important in the sense that all of us, or almost all of us, at some point or another, is approaching the government, some permitting agency, to pull a permit to do something with our property. Anyone who owns a home or owns a vacant piece of land, whether it be commercial or residential, has to go through this process. And so these cases, Nolan and Dolan and then Koontz, will apply to those permitting applications. And so in that sense, it's a very broadly applicable area of takings law. In Nolan, you had a coastal landowner who simply wanted to replace a bungalow with a single-family home, like all of his other neighbors along that strip. So it was completely approvable under the existing zoning rules and regulations. When his permit went before the California Coastal Commission, however, the Coastal Commission said, we approve your permit application subject to the condition that you first dedicate an easement across the backside of your property, that is to say, along the beachfront side of the property. And the Nolans, one of whom was a lawyer, looked at the condition and said, this can't be. I mean, I'm just simply enlarging my home. I'm not destroying public access elsewhere on my property. And so why should I have to give to the state an important, valuable interest in my real property? Especially when he had some privacy concerns. This public access easement where the beach-going public could go back and forth in his backyard, they would be able to peer into his living room. And it was that close to his home. And so he challenged the condition as an extortionate condition on his permit application. And the case went all the way up to the United States Supreme Court. And the Supreme Court held that the government cannot exact an interest in real property in the permitting process unless the government can show that there is an essential nexus between what the government is asking for, in this case an easement, and the impact of the project. So, for example, if the Nolan's development would have destroyed existing public access somewhere, then the government might have been justified in demanding a public access easement somewhere else on the property as mitigation. But the commission simply couldn't do indirectly what it couldn't do directly, and that is to say, simply take an easement from the Nolans without paying just compensation. That was a burden on the Takings Clause right to just compensation. So over the years, the permitting agencies across the country tried to create exceptions, tried to narrowly apply Nolan predictably. And they said, well, look, Nolan applies only if the government is extorting a real property interest, like an easement. And Nolan applies only if the government approves a permit with a condition, what we call conditions subsequent to permit approval. If the government takes money, if the government takes another interest in property that is not real property, then Nolan's heightened scrutiny doesn't apply. The government doesn't have to show any kind of a connection between what it's asking for and the impact of development. Or if the government, say, in a closed-door meeting with the permit applicant says, hey, we're not going to approve your permit in the first instance unless you first agree to our extortionate demands, then Nolan doesn't apply because that would be a denial of a permit. And if you have a denial of a permit application, you really don't have anything to sue over a condition because there's no condition attached anywhere. And so the governments across the country try to create these exceptions to Nolan and essentially try to swallow the rule that Nolan provided. And in a subsequent decision in Dolan involving also real property exaction that was imposed subsequent to permit approval, the court said there also has to be rough proportionality. So we have these two tests, a nexus, an essential nexus, and rough proportionality. Over the years, Pacific Legal Foundation and other property rights advocates tried to get these issues before the United States Supreme Court in vain. We tried to get the Supreme Court to decide that no, Nolan and Dolan, these are generally applicable rules that should apply to all exactions of property, whether it be for money or for real property. And it should apply in any context, whether the government is denying you a permit subsequent to your refusal to accede to an improper condition, or whether the government approves your permit application with a condition. So there's no difference, in our view, between a condition precedent and a condition subsequent to permit approval. Then along came Koontz, and in Koontz, the government, as the judge explained, decided to impose as a condition precedent to permit approval this requirement that Koontz not only dedicate 11 out of 14 acres of his property to a conservation easement, but also that he pay up to $150,000 hiring contractors to perform off-site mitigation work to government-owned lands located miles and miles away. And he accepted the 11-acre conservation easement, but he could not, given his modest means, could not accept the $150,000 exaction that he pay for off-site mitigation. And the government agency in that case refused his permit. They denied it outright at a hearing. And they argued in the courts that, look, this is not a Nolan case. We denied the permit application. There's no condition anywhere. And number two, we just asked for money. We just imposed a financial obligation. Went up through the courts. The Florida Supreme Court held against our client, Coy Koontz, and then the Supreme Court last year took up the issue. What's interesting about the Supreme Court's decision is that the court was unanimous on one of the issues, and that is to say that all 9 justices agreed that there is no difference between a condition precedent and a condition subsequent to permit approval. It doesn't matter how the government frames its extortion. It's going to be subject to this requirement that it show first the connection between the condition leading to permit approval and the impact of the project. So that was a unanimous ruling on the part of the court. On the money question, you had 5 justices, led by Justice Alito, decide that money is property, surprisingly enough, under the Takings Clause. Imagine that. And at the oral argument, actually, it was interesting to see the back-and-forth exchange, in particular between Justice Scalia and the Solicitor General. The Obama administration did intervene on behalf of Florida, and the Florida attorney. Justice Scalia was, how is money not property protectable under the Takings Clause? It defies imagination how that could possibly be the case. And so 5 justices did decide that money is private property, your private property protected under the Takings Clause. And if the government imposes a financial obligation on you that is connected to real property, as in this case, then you are protected under the Takings Clause, and the government and the Nolan rule is triggered, whereby the court or the agency has to demonstrate the connection there between the money demand and the impact of the project. An extremely important principle that the court upheld. The court did say that that was a per se taking, so for you property rights buffs out there, you know the difference between a per se taking and the other kind of nasty rules out there that always go against property owners, that require kind of a balancing between interest of the property owner and the government purpose. This is when the government demands money from you in the context of a land use permit, that's a per se taking. And it burdens your right to just compensation if the government can't demonstrate that connection. What is the future now that we have Koontz? For land use regulation, for taxes, user fees, and the like, you had the dissent going on and on and on about how you wouldn't be able, after Koontz, to distinguish between taxes, user fees, and the like, and monetary exactions in the land use permitting context. Well, you can. Taxes aren't imposed in the land use permitting context. Fees are imposed. Mitigation fees, user fees, impact fees, in lieu fees. These are the sorts of things, monetary obligations like you saw in Koontz, these are the sorts of things that are readily distinguishable from taxes and other kinds of user fees outside the permitting context. So as a practical matter, and this is the point the majority made, it's not really too hard to distinguish between taxes and user fee, and taxes and the like, and monetary exactions. What does this mean, though, for the future of land use regulation? Well, I hope it means a lot. We will continue to argue moving forward in other cases as we bring them in through the federal courts and the state court system that any time a financial obligation is imposed on a property owner as a condition of his exercise of the right to use and develop his property, anytime that happens, Nolan and Dolan and now Koontz scrutiny needs to be applied. The government needs to show what the connection is. And if that even means that some zoning regulations that impose real costs on property owners, maybe not a direct financial obligation, but impose real monetary costs on behalf of a public good, well, maybe in those cases, Koontz should also apply, and the government should also bear the burden of demonstrating what the connection is between this zoning rule, say an excessive setback or a height restriction, or maybe an aesthetic rule that impose real costs on property owners. How is that connected to the impact of his development? So we hope to see, frankly, a much more expansive application of Koontz in the future, I think the court did leave some room, possibly, for that kind of application. There are questions as well that we can discuss later about what about these sort of ad hoc adjudicatory exactions not required by a legislative rule like an ordinance or a statute, but how about when the planner, or I'm sorry, how about when a city council or a county board of supervisors or a state legislature requires a generally applicable exaction, monetary or otherwise? What does Koontz have to say about that? Well, Koontz did not discuss that issue specifically, but I think some of the language in Koontz does allow for a very broad application of Nolan and Dolan. That is to say that it doesn't matter which government agency is doing the extortion, whether it be the city council or the board of supervisors or the state legislature or a rogue city planner. It doesn't matter who imposes it. These sorts of conditions always need to be subject to heightened scrutiny, and the government always needs to demonstrate an essential nexus and rough proportionality. Thank you.
Thank you, Paul. Congratulations on your win. I will now hear from Professor Steck.
Okay, 7 years ago, in response to the Supreme Court's decision in San Remo, I wrote an article entitled "The Demise of Federal Takings Litigation," reflecting my view that the twin procedural obstacles of ripeness on the one hand and preclusion on the other hand would make it virtually impossible for a landowner to bring a takings claim directly in federal court when the alleged taking was the work of state or local governments. Well, 7 years later, I'm going to cast my remarks as the persistence of federal takings litigation, because despite San Remo, landowners continue to seek relief from oppressive state and local regulation in the federal courts. They do so by employing a variety of strategies, most of which are consistently unsuccessful. But recent cases hold out at least some promise for landowners who are seeking to avoid those twin obstacles of ripeness and preclusion. So first, a little bit of background, a brief summary of the problem. In the Williamson County case, the Supreme Court indicated that a takings claim could only proceed in federal court if the landowner surmounted two obstacles. First, the landowner had to demonstrate that municipal officials had made a final decision. And second, the landowner had to show that landowner had sought and been denied just compensation from the state, so that landowner had to go through those two processes in order to ripen a claim in federal court. But then in San Remo, what the court did is to say, well, if a landowner actually brings a claim in the state court and seeks just compensation, and the state court decides that in fact there was not a taking entitling the landowner to just compensation, landowner would be precluded by issue preclusion doctrine from then raising the same claim in federal court. So if a landowner fails to go to state court, the claim is unripe, and if a landowner seeks relief in state court and loses, then the claim is precluded. So the question that I want to focus on is, within that framework, what room is there for a landowner who is seeking to proceed in federal court to begin with? And so first, let's consider some of the strategies that have been unsuccessful. First unsuccessful strategy is to try to cast the takings claim as something else, a due process claim, an equal protection claim, and hope that those claims won't be subject to the Williamson ripeness rules. Well, although many landowners try that technique has typically been unsuccessful for two reasons. One is that when the landowner's basic claim is the harm done to the landowner by the magnitude of a restriction imposed by a municipality or a state, it's hard for courts to view that as anything other than a takings claim. And so if a landowner, for instance, is prohibited, as happened in a 2012 case in the Ninth Circuit, from building a dock on his property, it's a little hard for a court to view that as a due process claim or an equal protection claim, even if that's the way the landowner styles it. And so courts are likely to say, just dismiss the claim on the merits. But the other problem is that a number of circuits have said, well, if a landowner is making a claim about a land use regulation, even if the claim is a due process claim or an equal protection claim, we're still going to apply the Williamson ripeness requirement. The landowner still loses. So that strategy seems to have been largely unsuccessful in the lower federal courts. Second strategy that landowners have used is to try to cast their claims as a facial challenge to the regulation, a facial takings challenge, rather than an as-applied challenge. And just recently, the Ninth Circuit faced one of those when the landowner was claiming that a regulation that essentially forced him to use land as a mobile home park and made it impossible for him to use the land in any other way constituted a facial taking. But the problem with these cases is the Ninth Circuit basically said that under Penn Central there aren't any facial takings claims. And so again, this strategy seems to be doomed to failure for the most part. A third sort of claim that fails routinely is invoke the futility exception to the Williamson County rule. That is, the courts have suggested, well, if it would be futile to seek state compensation because it was clear that the states were not providing a mechanism for obtaining compensation, then maybe you can go directly to federal court. The problem with this exception is that the federal courts have been extraordinarily reluctant to hold that a state court, or a state in general, is withholding protection that the Constitution mandates. So a landowner recently tried this strategy in the First Circuit, saying that Rhode Island didn't have adequate procedures for providing remedial relief, and the First Circuit held no, that in fact there's no reason to assume that Rhode Island would evade its constitutional obligations. Okay, so these strategies are have all been unsuccessful. What might be more successful? Well, probably the most promising strategy that seems to be out there now is to contend that the Williamson ripeness rules are merely prudential and not jurisdictional, and that the landowner is entitled to, in some cases at least, go to federal court, and the federal court need not dismiss on jurisdictional grounds. The Supreme Court has opened the door for these claims by making the suggestion that the ripeness requirement, especially the critical second ripeness requirement, is only prudential, both in the Sudom case and in the Stop the Beach case. And it suggested the same thing again in the Horne case decided this past term. But without specifying at all when the Williamson rule ought to be relaxed, other than to say that it's prudential. Now, the Fourth Circuit has, just this summer, taken up the opportunity that the court opened up and held that a federal claim could be heard in the Fourth Circuit, in the federal courts, in Sansota versus Nag's Head. And I think this case is illustrative. Both, it's a useful case to think about, both for substantive reasons and the procedural reasons. And so I just want to digress for a minute about what was at stake in the Sansota case. The landowner owned 6 beachfront cottages in an area that was rapidly eroding. By 2001, in fact, the cottages were already on the beach side of the vegetation line. Okay? And in 2009, a large storm washes away most of the sand, exposes the septic tanks, causes other damage. And the town declares that the cottages are nuisances, precludes the landowner from rebuilding, and precludes the landowner from basically doing anything with these cottages. So just pause for a minute. Is this landowner a victim, or is this landowner the villain? Right? We ordinarily tend to think of landowners as victims of regulation, but it might be worth thinking about the fact that ultimately what happens is the town comes in and spends $36 million of public money in order to rescue this landowner's and neighboring landowners' beach. But let's leave that aside. That's the digression that suggests that sometimes takings cases are harder than one might expect. But the procedural issue arises, and this is the one that I want to focus on, when the landowner decides to do exactly what Williamson County tells the landowner to do: bring a claim in state court. Landowner brings the claim in state court, and what does the town do? The town removes to federal court and then immediately moves to dismiss on ripeness grounds, right? So you get what the picture is. And so now what happens is the case gets to the Fourth Circuit, and the Fourth Circuit says, well, wait a minute. This is a case where the town waived its ripeness claim by removing to federal court. Sounds very sensible, but that claim only works because, or if, we conclude that the Williamson rules are prudential. If they were jurisdictional, presumably it wouldn't matter. If the federal courts didn't have subject matter jurisdiction, they couldn't hear the claim. But so the opening up of Williamson County by labeling these rules prudential certainly helps in the case where what the town tries to do is remove the case and then move to dismiss on ripeness grounds. But what the Fourth Circuit also did in a related case involving the same beachfront the next month is to allow a claim by a landowner that the landowner initially brought in federal court to proceed in federal court on, again, the ground that the Williamson ripeness rules were only prudential. What the Fourth Circuit didn't do, though, is give any indication of how it would apply this exception in any other cases. What standards would apply? Under what circumstances would these claims be able to go forward in federal court? And the few cases that have tried to do the same thing in other circuits have also been largely devoid of much content about when the Williamson rules might be avoided. Now, even if we ended up with a somewhat broader rule that allowed landowners to proceed to federal court, that wouldn't exactly be a panacea for landowners. For instance, the Ninth Circuit has taken the opportunity to use the prudential, not jurisdictional rule in a case where a landowner was complaining about a case that seems to be rampant in the Ninth Circuit, mobile home regulation. And so landowner comes in, says this mobile home regulation was a taking, brings the claim in federal court, and what the Ninth Circuit does is to say, okay, well, instead of doing what we would ordinarily do is dismiss on ripeness grounds, we're going to just dismiss on the merits. And that leaves the landowner not able to go back to state court to raise the claim on the merits in state court. It's not clear exactly what the landowner gained from application of the prudential, not jurisdictional rule. All right, so where does that leave us? What limits will there be on the prudential exercise of federal court jurisdiction? I think it's too soon to say. The next question is this good for landowners? And again, I think the answer is uncertain. I've been doing a lot of reading of lower court takings cases, both in the state and federal courts, over the last 30 years. And one of the things that is notable is that it's not at all clear that landowners do any better, either before or after Williamson County, in federal court than state court. The same sorts of general results that we've heard people describe seem to apply roughly in the same proportion in state and federal court. So whether greater federal court jurisdiction will actually help landowners is a matter on which at least I'm fairly skeptical. Thanks.
So my comments follow very nicely from Stuart's comments in the sense that I would like to try to outline for you a theory as to why Williamson County's second ripeness requirement should be overruled, and indeed why equitable relief for takings should be available in selected circumstances. So Stuart, I think, has established that remedies are important in the takings clause area. Those of you who are old enough to remember may recall that back in the 1970s and 80s, remedies were a very hot issue. The California Supreme Court had held that the only remedy for a regulatory taking in California under California law was an injunction. You could get the regulation enjoined prospectively, but there was no remedy under California law for damages for the regulation while it had been imposed. After many failed attempts, the U.S. Supreme Court finally reviewed that issue and held that it violates the takings clause, that if a regulation is invalid under the takings clause, you're constitutionally entitled to temporary damages for the time in which the regulation was in effect. So that was a situation where the state had contrived a system of remedies that worked to its advantage by delaying any attempt by landowners to get redress. The longer the state courts delayed conclusive resolution of the takings question, the more the landowner was hung out to dry, and eventually many of them, of course, gave up along the way. Shortly after, First English Evangelical Church scuttled the California rule of injunctions only, no compensation. The Supreme Court in Williamson County adopted sort of the opposite rule, which was that the only remedy for a taking is compensation. Therefore, you have to seek, as Stuart described, you have to go to the state and seek compensation from the state, and only if the state denies you compensation can you come back to federal court. This also had the effect of hanging property owners out to dry because they have to undergo this long gauntlet of seeking compensation in the state courts, and many of them give up along the way. So remedies do matter, maybe ultimately on the merits of federal court, state court, hard to determine who's going to be more sympathetic, but the delay factor certainly weighs on the minds of many people in seeking, considering whether or not to bring takings claims. So if you look at the Supreme Court's case law, there are two lines of decisions about remedies, it seems to me. There's first of all what I'll call the A line of decisions, which in the federal takings context goes by the name of the Tucker Act doctrine, and in the state context goes by the Williamson County doctrine. And these decisions say that the only remedy for a taking is just compensation, and the only way you can get compensation is by filing a claim in a particularly designated court. In the case of federal takings, it's the Court of Federal Claims. Under the Tucker Act, in the state context, it's whatever state law indicates as the court that has authority to issue inverse condemnation judgments or otherwise state claims court type jurisdiction over takings claims. That's the A line of decisions. There's also, however, a B line of decisions. And the B line of decisions essentially are cases where the Supreme Court either declares that something's a taking or perhaps enjoins something as a taking and makes usually no reference to the A line of decisions, but simply issues equitable relief without any discussion of it. Or at least in one case, the Eastern Enterprises decision, the plurality opinion by Justice O'Connor acknowledged the inconsistency and said that in those circumstances, the, quote, unique nature of the takings claim, close quote, justified equitable and declaratory relief rather than submitting the case to the Court of Federal Claims. So you've got these two lines of decisions, and what interests me about these three cases this last term and going back a little bit further, the Stop the Beach case, is that at least three of those cases are B-line cases that authorize declaratory or injunctive relief without attempting to square this up with the A-line of cases. And so it led me to start thinking about which of these approaches is correct and which one's incorrect. And I've come to the conclusion that, in fact, the B-line is more correct than the A-line. So the A-line cases, I think, if you unpack them, rest on two premises from which a faulty conclusion is drawn. The first premise is that the nature of the takings clause is to create a right for compensation only. I think this is a correct premise. I think if you read the language of the takings clause, it says, nor shall private property be taken without for public use without just compensation. The operative provision is without just compensation. The takings clause is a specific right to compensation for takings for public use. There are other things that happen to property owners that are bad. They don't get hearings, or that perhaps the government acts in an irrational fashion in taking their, interfering with their property. But those are usually governed by some other clause like due process, not the takings clause. So the first premise is the only remedy for a taking is compensation. The second premise is based on sovereign immunity. The Supreme Court has recognized that both the federal government and the states recognize, as a matter of implied constitutional interpretation, immunity against lawsuits unless they have waived their sovereign immunity. And in the takings context, that means that the legislature, either the Congress or the state legislature, has to waive immunity from suits for damages for takings before you can file a suit against the state or the federal government for a taking. And again, I think, so the inference that leads to is that if there has been a waiver of sovereign immunity and the waiver narrowly directs you to a specific specialized court, like the Court of Federal Claims for federal takings or some kind of state court, designated state court for a state taking, that waiver has to be respected. That's the only court that can enter a judgment for compensation running against the state. There are various exceptions to this under the ex parte Young and so forth, but they usually don't entail compensation certainly compensation paid for by the states. So the flawed conclusion that's been reached from these two premises is that the only the only remedy that a court can ever enter into in a takings case is compensation, and that the only court that can give you that relief is the specialized court of limited jurisdiction that is authorized to enter money judgments. I don't think either one of those conclusions follow logically. Even if it's true that the only remedy for a taking is compensation, it doesn't follow that a court could not issue equitable or declaratory relief stating that a party is entitled to just compensation. I agree that the courts can't issue injunctions blocking the taking itself. They can't say that the government can't do this or can't do that with respect to land use regulation, but they could enter a declaratory judgment or perhaps even an injunction ordering that the plaintiff is entitled to compensation. Secondly, even if the only court that is entitled to enter judgments of compensation is the Court of Federal Claims or an analogous state court, it doesn't follow that courts of general jurisdiction can't issue equitable judgments stating that the party is entitled to go to such a court and to file an action seeking just compensation. So I think the conclusion the court has drawn in these A-line cases, like Williamson County or like Praysalt involving the Tucker Act, is logically incorrect. And I think that in appropriate circumstances, courts should be able to issue equitable relief, provided the equitable relief respects these limitations, that the only remedy for a taking is compensation, and that the only court that can issue a judgment requiring the court to pay is the designated court of special jurisdiction where there's been a waiver of sovereign immunity. So that being said, I don't think that courts should routinely grant equitable relief for takings. I think that the appropriate way to handle this, and I think the court in Horne and Stop the Beach and Sudom has hinted at this by talking about the prudential nature of the ripeness requirement as opposed to the jurisdictional nature. I think the appropriate doctrine here is really abstention. There are lots of abstention doctrines that apply in circumstances where people file lawsuits in federal court and the court decides that it's best to abstain and remit the parties to an action in state court. None of them exactly applies here. I think Thibodeau abstention is the closest analog, which is an old case, Justice Frankfurter decision in 1960 that involved the question whether the state had authority to take certain railroad property by eminent domain, and the court said we should abstain and let the state courts decide this first. The argument that I'm suggesting is broader. It's a broader abstention doctrine that could apply in between two federal courts as well as between federal courts and state courts. It could also apply as a matter of state law as between two different state courts. But the basic notion would be drawn from the law of equity, which is as long equity will stay its hand as long as the remedy in damages is adequate. So if the court is presented with an equitable claim for declaratory or injunctive relief and concludes that in fact fully adequate relief could be obtained by having the party file in the court of specialized jurisdiction and obtain a judgment for compensation, it should abstain. It should tell the parties to go to that court. But if there's a controlling issue of law presented, and if the court concludes that the litigation would be more expeditiously resolved, if the court were to resolve the controlling issue of law rather than remitting the parties to the court of specialized jurisdiction, I think abstention would not be warranted, and it's appropriate for the court to proceed. So very quickly, 3 of the last 4 cases, I think, suggest that the court is kind of groping unconsciously towards some kind of conclusion like this. Stop the Beach Renourishment case from a couple terms ago involved the question of whether judicial takings are cognizable under the Takings Clause. And there was an interesting debate between Justice Scalia, who wrote for a plurality of 4 justices, and Justice Kennedy, as to whether an action for judicial takings is consistent with the fact that the only remedy for a taking is compensation. Justice Kennedy says, how exactly is this going to work if you're challenging some court decision as a taking and your only remedy is compensation? Who's going to give you the compensation and so forth? Justice Scalia responds, I think, in a very puzzling fashion by saying, well, this is simple. We'll just invalidate the state court decision under the Takings Clause. And you sort of left scratching your head about that. I think the correct answer that Justice Scalia should have given is that in appropriate circumstances, i.e. when a state Supreme Court renders a decision that creates, in effect, an arguable judicial taking, the U.S. Supreme Court is entitled to enter declaratory relief, saying that what the state Supreme Court just did was taking of your property. Armed with that declaratory judgment, the party can then go back to the state court that has jurisdiction to award compensation, and it would be a matter of res judicata that this was a taking, and they could sue for a taking in the appropriate state court. Or consider the Horne case that was decided this last term. The Supreme Court in that case said that the Hornes, who were raisin growers, were entitled to raise defensively in a court of general jurisdiction in the Ninth Circuit the claim that this enormous fine that was referred to by Judge Clement was a taking of their property. And so the court, in effect, and the court said that there was an exception to the Tucker Act here because of the comprehensive nature of the relief and the remedies provided by the Agricultural Marketing Act. But that's just not even plausible. I mean, the Agricultural Marketing Act doesn't say anything about compensation, doesn't say anything about takings. What the court should have said in Horne was that, you know, it would make sense for the Ninth Circuit to resolve the takings claim, and if they can resolve it as some kind of facial matter, then they should enter a declaratory judgment. And then if the Hornes are still entitled to compensation, then they file their lawsuit in the Court of Federal Claims, and they go and seek compensation. The third case was Koontz. Koontz is the most fascinating of all. The Supreme Court decides, as was described by Mr. Beard, the Supreme Court decides that conditions subsequent are no different from conditions precedent, or vice versa. I can never get them straight in my own mind as to which is which here, and that you can challenge an exaction even though the exaction has never been imposed, and so there's never been a taking. But this is fine. The court basically says that threatened exactions are actionable as well as actual exactions, and that's consistent with unconstitutional conditions precedent more generally. But if it's true that the only remedy for a taking is compensation, and you have to get the remedy from a court of specialized jurisdiction, how are you going to remedy this threatened exaction consistent with these other precedents, these A-line precedents that the court talks about? And Justice Alito ducks this whole thing by saying, well, the remedy of compensation is just a matter of state law, and they can decide on remand whether or not they're going to get damages for this. And Justice Kagan hammers him and says, look, the guy asked for compensation. The only authority that the jurisdictional provision has that he invoked is compensation, and I don't see how there's any way that this claim is going to survive. I think, again, the answer should have been that when there's a threatened exaction and it's a final decision by the government, that you can ask for declaratory and injunctive relief. And if the court concludes that, in fact, it is an exaction, it would declare that it was going to be an exaction, and then at that point you can go and seek compensation if it's, for example, been a temporary taking, as it was in the Koontz case, that gives rise to money damages. So I think the court's recent cases suggest that there's very much a need for this type of equitable relief. I don't think logically there's anything in the nature of the Takings Clause or the waiver of sovereign immunity that precludes equitable relief. I think on an appropriate occasion, the court should take up the invitation of the four dissenting or concurring in the judgment justices in San Remo. Justice Rehnquist wrote an opinion in that case for four justices saying we should overrule the second half of the Williamson County case. I think an appropriate occasion, the Supreme Court should do that and should acknowledge that, in fact, equitable relief is appropriate under the Takings Clause, provided we respect these principles that I've described, and provided that ordinarily, in most cases, we'll expect courts to abstain from granting equitable relief. Thank you.
All right, thank you. I think Dean Huffman raised the question, what do you tell your client? And so I would like to ask the panelists to go back and review what the other panelists have commented and maybe give us a little clue as what do you tell your client, what do you tell your law students, how to approach this, and hopefully where do you file so the judges you file before know what to do. Thank you. You want to start?
Well, is this on? I guess the one comment I would have, and maybe a short question for Tom, is that the argument I really made, I guess to answer your question, Judge, directly, I don't know what you tell your students. I think you can teach them about the intricacies of arcane property or takings doctrine, and my fellow panelists have well described pieces of that. And that's probably important for people who are going to go out and practice law and represent property owners. But on the other hand, consistent with the remarks I made, I think we need to teach our students at least, if not our clients, about the sort of core underlying principles of the Takings Clause and what it stands for and why it's fundamentally flawed, in hopes that in the process of pursuing the arcane intricacies of taking law, we might move the court to reconsider some of these questions. And I think an opportunity for that was in the Koontz case. As Stuart described, they spent a whole lot of time talking about whether the difference between a tax and a fee or an extortion. And it seems to me if they step back to a statement that's been made repeatedly, quoted repeatedly from the Armstrong case, which said that, quote, the Takings Clause is designed to bar government from forcing some people alone to bear burdens which in all fairness and justice should be borne by the public as a whole. That's more a statement about equality than it is about property rights or takings. And so this, in trying to avoid the ripeness and preclusion obstacles, some discussion of the importance of the concept of equality to takings law seems to me appropriate. I think if the court, in trying to distinguish between a tax and the fee that was imposed in that case, focused on the fact that a tax, to be valid, has to be generally applied, at least in some plausible sense. You cannot, I don't believe, that the government can tax a particular property owner at any amount that it chooses and move on to the next property owner and impose a different tax, but that's exactly what happens with these extortion fees. So to me, that's the easy explanation. It goes to equality of treatment. It goes maybe to due process. But that's an issue the court, I think, just doesn't address. My question for Tom, and maybe this is a silly question because it may be an empty set, but what about takings where there is no public use? Obviously, compensation can't be the remedy in that case, right?
That's a recognized exception, yeah.
Right.
Yeah, I specialize in exaction, so I can speak to Nolan Dolan Koontz type of case, and I think that you know, we've seen problems even with exactions claims running up against Williamson County. I had a case out in the 10th Circuit where we challenged under Nolan Dolan the propriety, the constitutionality of a law that forced developers to dedicate something like 30 to 40% of their housing units to affordable housing, so at subsidized market rates. And we said that, look, the developer himself is not creating the need for affordable housing, so why should he be made to bear the burden of supplying affordable housing for the community? And so we thought that was a Nolan Dolan claim. We sought declaratory and injunctive relief, sued in federal court, and the court there, the 10th Circuit, issued a very bad published decision in which it said that we had failed to meet the second prong of Williamson County, that is to say that we failed to file in the New Mexico state court system for damages, even though we weren't seeking damages. They just applied it, I think, as some other courts have as well. They applied this rule across the board. And so I think our practice has been now to file in state court. That's a sure way, at least, to get your Nolan Dolan claim, your Nolan Dolan relief. And in Florida, we're lucky to have in Florida, and I think some other states, a state law that does explicitly provide for damages for temporary takings that are affected by an unlawful regulation, or in this case, an unlawful exaction. So that's why the Koontz case was a bit confusing to many who didn't know the background facts. Koontz actually sought a declaratory and injunctive relief on the permit condition, so he wanted the permit approved without the offending condition, and he got that, actually, way back when. But he also sought damages for the temporary taking. I think it was 11 years during which he could not use his property because he had been denied the applications. And so he successfully also obtained damages of over $300,000 for the temporary taking of his property, resulting from the unlawful imposition of this condition and the unlawful denial of his permit application. So Florida is one of those great states that has this state law provision that allows for damages for takings, temporary takings. And I think that's what Justice Alito, in his majority opinion, was referring to when he said, when he was responding to Kagan, look, this is not a federal takings compensation case. And they sought, the Koontzes sought merely injunctive relief under the Nolan-Dolan lines of cases. And if they had a damages claim, that was under state law, and it's not for us to decide whether or not that's available. And so there were really two kinds of remedies specifically sought by the Koontzes. The only federal one that was before the court was whether Nolan and Dolan applied to this kind of a monetary exaction, whether it was, whether he was entitled to equitable relief. So it would be nice if I don't know how many other jurisdictions like Florida have this kind of state law remedy for damages, but it would be nice if all of them did.
You know, I'm quite fascinated by this because I don't think any of the opinions in the Koontz case by the Supreme Court acknowledged that this was a temporary taking case. I mean, it was sort of in the briefs, but it was not terribly clear.
Right, it was in the briefs because the government had raised this as a temporary takings damages case to which Nolan and Dolan don't apply. And our view was, in our briefs, was that they had confused the issues. There were two issues. There was a state law that allowed for damages for the unlawful taking of property, but you don't have a temporary taking, an unlawful temporary taking for which you're entitled to damages unless you can first show that there was a Nolan-Dolan violation. We were only litigating the Nolan-Dolan violation. That was the only issue that made it up to the Florida Supreme Court, and that was the only issue that was before the U.S. Supreme Court. That is to say, the only question was whether Nolan-Dolan applied to monetary exactions, making this condition unlawful.
The thing of it is that if it had been clear that this was a temporary taking, then there would be yet a further layer of the onion that would have to be dealt with. And I mean, Koontz is already a complicated enough case. It sort of gives you a headache to try to understand it all. But the further layer would be that, you know, the court says that an exaction is a per se violation, or at least the taking aspect of it is a per se violation. But if it were a temporary taking case, then you'd have this Tahoe Sierra argument that temporary exactions as opposed to permanent exactions are subject to Penn Central as opposed to per se liability. And boy, then you'd really have a complicated sort of layers and layers and layers of complication. And so I think it's sort of merciful that the court didn't, if it knew that this was a temporary taking, didn't highlight that feature because it would have made what was already a very complicated set of arguments even more complicated. But I think it's an open issue in the future as to whether an exaction, which is then invalidated, and then you sue for compensation for the temporary time period, is going to be treated like a permanent exaction or whether it's going to be treated like a Tahoe Sierra situation.
Professor Stack, do you have a solution?
Well, I don't think I have any solutions here, but in terms of where, if you were advising a client where to go, I think partly it's going to depend on what the nature of the claim is, but I think even if the court were to go as far as Tom suggests in opening up the ripeness requirements, that's still not going to go, at least in the typical state or local claim where the state or local government is a defendant, still not going to get you very far into getting into federal court, at least at the initial matter. I think for the most part, you're still going to end up having to be in state court because the abstention doctrines will replace ripeness claims in most of the cases.
And you'll still have the first finality requirement.
Right. Well, but even aside from that, even if you surmount the first, even if you're only dealing with the second requirement, I thought I was hearing you suggest that in most cases abstention would get you put back into state court.
In a garden variety case where somebody claims that the government took their property, you know, that they should have filed an eminent domain action, but they didn't, that's an easy abstention case.
Right.
I'm thinking of more, I mean, the more unusual cases, like one case that's interestingly pending right now is the Detroit bankruptcy. And an issue that's arisen in the Detroit bankruptcy is whether public pensions that are vested and fully funded are property protected by the takings clause, such that if a federal bankruptcy judge compromises or restructures them, that's a taking. Now, to me, it would not make any sense to tell the employees, oh, you know, we're going to abstain from deciding this, and after we've reorganized Detroit, you guys can file a suit in the Court of Federal Claims and have the U.S. government pay your pensions in one lump sum. I think it would make much more sense to decide the takings issue and then weave that into the overall bankruptcy judgment and as to what's equitable among the various creditors in that case. And so that's a perfect example of how we need some kind of equitable doctrine that does, it's subject to abstention in most cases, but in some special cases, courts can go ahead and decide the takings issue.
No, I think I agree with you on that. I think the hard, but for the run-of-the-mill land use regulation case, I don't think federal court is ultimately going to be much of a venue for those suits to be brought.
Anybody else? We have a few minutes for questions if anyone has any questions. Not that they have any answers, but we'll see. Yes, sir. If you would stand so they can hear what you have to say. Thank you. We don't have a mic, but.
Can you hear me? So this is a question primarily for Stuart Sturck, but others may want to comment. You said that it may not be of much benefit to property owners to be in federal court as opposed to state court, because on average, it's not clear that federal courts are more favorable to property owners. But doesn't that depend on what state you're in? There are some states where are very favorable to property rights, and other states which are very hostile, and so maybe you have the same situation here as with other constitutional rights. The reason why there's a federal court option is not because all state courts are hostile, but because there's variation between them.
I think that's fair. That's a fair point, Ilya, but I think if you start looking even at the states, variation among states, there's not enough variation among federal courts that shows that the federal courts are a substantially more favorable option than what you have in state courts. That the prevailing problem that landowner plaintiffs almost always lose seems to be true, at least with regulatory takings claims, in the federal courts, and therefore it's not clear how much better the federal courts are as an option. Now, it's true that many of those cases today, federal courts don't get to hear because of ripeness doctrines, and so we don't know what would happen if we eliminated ripeness doctrines. But even before Williamson County, it's not clear that the federal courts were very hospitable to what we might call as Penn Central takings claims.
Yes, sir.
I'm Sam Miorelli from Orlando, and I'd just like to thank Mr. Beard for his work against the tyrannical South Florida Water Management District.
Thank you.
And I was going to ask about sort of the next step in going after these ridiculous organizations that we have in the state of Florida. Because you know, what I've seen in trying to work some permits through these places is especially the local governments that see some difficulty in this stuff, say, okay, well, instead of demanding land or some of these things, because our county attorney tells us that's very difficult, let's just take a huge amount of money. And if you want a permit, you need to pay us $25,000 or $100,000 or whatever. And I just wonder, you know, in light of Koontz, you know, these people have been paying taxes all along. There's not really much evidence, especially on some of these projects, that they're going to really impact anything. And they call it an impact fee. And I'm wondering if you think that Koontz can be extended, maybe specifically in states like Florida, to go after these ridiculous fees that get charged.
Undoubtedly. I mean, I think now based on our prior experience with the Nolan decision when it came down in '87, we saw some important readjustments on the part of various permitting agencies across the country who were now faced with this new test. And we saw a flurry of so-called nexus studies by all of these permitting agencies who went out of their way in order to avoid liability to show specifically the connection between what they were demanding and the impact of projects. And so we hope to see the same with respect to monetary exactions in those jurisdictions, in those many, many jurisdictions that before Koontz did not recognize monetary exactions as triggering Nolan-Dolan review. We think we're going to see either these kinds of exactions will recede, or if they're justified, agencies will go out of their way to provide these nexus studies. And incidentally, an interesting point that I always make when I have a more hostile audience is that there was a very interesting law review article published by UC Davis that had polled, I don't know how good the study was, but had polled agencies in California, permitting agencies and planners, and asking them, what is the effect of Nolan and Dolan? I mean, do you appreciate it? Do you hate it? And surprisingly enough, a good majority of planners said, we're happy with Nolan because it finally provides us with some guidance as to what we can and cannot demand. And I think over the years, while there has been a very bad reaction to Koontz by the left and city planners and the like, I think we're going to see them come around in the future, hopefully, and try to comply with the law and see that it's important to have this kind of guidance in place. But more specifically to your question, we're always looking for a good case, and we represent folks for free. So if there is an issue in Florida where Koontz is not being followed, and that's possible, the California Coastal Commission regularly ignores Nolan, even though they were the named defendant in that case. And I wouldn't be surprised if there are some rogue agencies in Florida and other places that ignore or don't know about Koontz yet. So, you know, we're always willing to take up a challenge to enforce the decisions that we've been able to obtain from the Supreme Court.
Just a question for Paul. Did the reaction to Nolan, was it in the substantive kinds of exactions that were made, or just in the justifications offered by government for exactions that it would have made anyway? That is, did they engage in nexus, these sort of these nexus analyses to justify what they were already doing?
Oh, post hoc? Yeah, no. I think we've seen both, actually, and we've challenged that kind of post hoc rationalization. When cities or counties or states have been imposing an exaction for years and years without justification, then they scurry to write a nexus study for some kind of a post hoc rationalization of what they've been doing. We think that really borders the line, probably unconstitutional. And so we've seen, but the majority of the nexus studies we've seen have been for new exactions where they've said, well, we think there really is an impact here, and we will explain in detail in our nexus study why we think these are justified. But I just want to raise one more point, and that is these nexus studies technically are unconstitutional as well, although they're good that they're happening. Because Dolan, the case that was decided in '94 after Nolan, made clear that the determination or the justification for an exaction needs to be individualized. And what that means is the government has to show why each particular property owner's impact justifies a particular exaction. So these kind of blanket nexus studies that say, you know, this exaction is justified for all property owners, regardless of their specific project or the impact on the environment, we think these are justified. That probably also violates Dolan, although we've never been successful in challenging it on those grounds, unfortunately.
I'm curious, Paul, about, I mean, the history of the Takings Clause, at least in recent decades, has sort of been that the Supreme Court, you know, citing the Armstrong case, will sort of expand protection for property owners, like in Loretto. They create the per se rule for physical occupations, or in Lucas, the per se rule for complete loss of economic value. And then there's kind of a reaction to that. So, you know, the new rule is created, and then a whole bunch of people file these lawsuits trying to work their case into the category that's now been created. And then these cases work their way to the Supreme Court, and the Supreme Court says, oh, we didn't mean that. You know, we didn't think pole attachments were covered by Loretto, or we didn't think, you know, trailer parks are covered by Loretto. And with Lucas, it's sort of like, oh, we didn't mean temporary moratoriums were covered by Lucas and so forth. So I'm a little concerned that Koontz is going to have a similar history, that, you know, Koontz says that monetary exactions are covered by the Nolan-Dolan nexus test, and then you and a bunch of other people are going to file all these lawsuits challenging various fees and so forth as being exactions, and then pretty soon the Supreme Court will say, oh, no, we didn't really mean that. And then the jurisprudence will be even more restrictive in some respects. They'll say that, oh, legislated monetary requirements are never covered, or, you know, anything that is called a fee is not covered. And so, I don't know, what's your reaction to that? I mean, is there some kind of danger here of pushing too hard? I think in the context of the Koontz case, it made perfect sense to say that this money exaction was just a substitute for a physical exaction. It was an in lieu exaction. And so I think on the narrowest possible grounds it was justified. But is there some danger to pushing too hard on these wins, and that they reap a harvest of sort of reactionary decisions?
Maybe, and we always have to discuss that internally as to whether we want to push the edges of a case that we like. But I think we're not very risk averse in that sense. So I think our general philosophy has been keep pushing, and we've never had a situation, I don't believe, that I am aware of, in which a particular a good property rights decision had been overturned. I guess Lingle, in a sense, might fall in that category, overturning Egan's, part of Egan's. But we've been pretty successful in, if not expanding the protections afforded by a property rights case, at least in a denial of that expansion, preserving what we had originally. So, you know, that's always the goal, is if we're not going to get an expansion, at least keep what we had before we filed the lawsuit. There is a risk of that, I suppose, but I mean, my dream, and the dream of many of us, I think, property rights advocates, would be to see all kinds of all zoning laws and regulations declared unconstitutional. And go back to a system pre-1920s where neighborhoods, entered into voluntary contractual agreements as to how high their houses should be, how much setback there should be, what color their home should be. All of this should be voluntary. And I don't know if we could use the Koontz case for that, because Koontz, as I said, involves a financial obligation. I don't know if we can transform that into, even when the government imposes a real cost on you, is that a financial obligation that you're dedicating to the public subject to Nolan Dolan? I don't know. But I am flirting with the idea, and it would be really nice to see a case decide the issue. So I recognize that there is a risk of pushback.
All right, anybody else? Yes, sir.
The court in Koontz doesn't really explain why the exactions doctrine only really applies to land use exactions. So I think there's no reason explanation for that other than we just don't want to expand this beyond the land use context because it might be dangerous, or is there an actual reason?
What other context are you thinking of outside the land use context?
Well, let's say, for example, in the International Star case, are you familiar with that?
No.
It's filing the court federal claims, claiming the AG is claiming, a stockholder of AG is claiming that when the Federal Reserve denied access to its discount window, and then it took shares in AIG, it took its property, and it also raised an exactions claim, or a unconstitutional condition. So it's kind of hard to explain why Nolan Dolan would not apply that property as.
Well, they
But
might.
Think of the Horne case. The Horne case on remand. You could say, well, okay, we're a handler, and in order to be a handler, which is a privilege under government regulation, the privileged status of being a raisin handler, you have to turn over tons of raisins to the government. That's a per se taking. So why not, treat that as an exactions case? Another example of how you could frame a lot of these cases, unconstitutional conditions cases.
Yes, sir.
Yes, Art Mackenberg, Coeur d'Alene, Idaho. I run a small retail property law practice in Washington, Idaho, and Montana. Most of my clients cannot afford takings claims. They are very complex and very difficult to move through any court. They take a long time, and unless they're like the Sackett's and get outside help, they're pretty much sunk. And my question for anyone on the panel who wants to tackle it is, the idea of a class action claim against a jurisdiction for the imposition of a zoning and ordinance or other, subdivision or zoning ordinance, a class action claim that the state has exceeded its police powers. The police powers in the land use context, at least in Idaho, are designed for prevention of health, safety, and nuisance problems. And there's a whole line of cases that substantiate that, but there's very little case law that goes outside it, although there is deference in the Idaho state arena for what the local jurisdiction believes is proper. So there's a traditional deference in the courts. It's a very passive court system. We don't make up equitable stuff like they do in California. It's very, very passive. If it's not in the law, you don't get it.
You know what, we're about to run out of time.
So that's my
if you
question.
have a question, please.
That is my question.
Okay.
Is
Does anyone have an answer?
the option for like a class action style lawsuit?
Well, again, if you were recognized equitable relief, that would make it easier to bring a class action. It wouldn't necessarily succeed, but you could say that once we break free of the understanding that you can only raise a takings claim when there's been a taking and you're seeking compensation, you might be able to frame cases as one seeking a declaratory judgment that this particular regulation exceeds the police power and hence cannot be applied without creating a compensable taking. So breaking the relief box open a little bit might facilitate class actions. Again, there still might be objections that would have to be surmounted, but I think it would help a little bit.
All right, let me thank the audience for being here, and if you please join me in thanking our panel for their insights.